You may proceed, Mr. Buchanan.
Good morning. May it please the Court. Robert Buchanan on behalf of Raytheon Company, and with me is Sam Bruskin. This case presents a question of first impression in Massachusetts, which has been addressed by courts in several other states. It involves the federal acquisition regulations that apply to U.S. government contractors and how those are dealt with under the state's sales and use tax.
Could I just ask you, because it's obvious from, I think, the briefs that the Raytheon is not arguing that it is an agent of the United States government in terms of these indirect cost items. Why is that?
Two reasons. One is that the federal acquisition regulations have requirements for what you would need to do in order to be as an agent. And those are similar to requirements under Massachusetts law, which are you qualify as an agent if the government directs in detail which purchases you make for what price, when, and so forth. And having looked at the Massachusetts law, we determined that we don't meet that standard.
Okay, thank you.
So thankfully, we present one issue to this Court for decision, not two. And the one is, do we qualify for the exclusion for resale in the regular course of business?
Can I ask you a fact question here, which I thought I understood, but I wasn't sure from whence it came. The indirect cost items that are purchased, everything from cell phones to toilet paper, at least as I read the record, to the extent that they are not completely used up in the course of the contract. We know that title passes to the government, but at the end of the contract, to the extent that Raytheon still has the cell phones and the extra toilet paper and stuff, what happens to them?
The record does address that particular question because the testimony and an affidavit as well are that under the accounting principles that apply, these items are deemed to be consumed within the year in which they're purchased. So these are usually multi-year contracts. So if items are purchased in the first year and the contract ends in the third year, they have deemed to be consumed.
Yeah, but what if they're not consumed? The cell phone still works, it's still being used? There's still toilet paper in the stock room. I mean, who gets title to it then?
So let me answer that in two ways. The first is, even if it's a cell phone, if it's under this accounting provision, it will have been deemed to be used up. But let's suppose that the contract is terminated for whatever reason during a year when there are still title interest in the U.S. government as to some pool of items. The terminating officer has the right to come to the site and exercise his judgment about what to do, whether to reallocate these items to another government contract or whether to bag up and tag and take some of them. And the closest case that's along the lines of Your Honor's question would be the one about American Pouch Foods, where a contractor went bankrupt. The contention of the U.S. government was that the government can go and take possession of items, never mind anybody else's lien, because the government has title to them. And the holding of the federal court was that's correct. The government has title to those.
So it's like a super security interest.
Well, it's more than a security of interest. The impetus for it is similar to a security interest. The U.S. government wants to have maximum financial protection, but the holdings of the federal courts are that it is actual title, and Congress has...
I use the word super security.
Sure. And Congress has said so, too. There was a maverick federal decision in 1982 which said it's just a lien. More courts said no, title is title. And Congress in 1998 passed a statute that says where a U.S. government contract provides for title, title shall vest in accordance with the terms of the contract. So
of course, the odd thing about that is that it might be 80% title. If they take title, what happens to the other 20%? And what happens to liens that are filed as to those other 20%?
Well, this is the odd thing about it. This is not an intuitive commercial arrangement. It's a type of arrangement which is special to U.S. government contracts. But the testimony is that if the contract terminates and there's still some indirect cost items to which the government has title, the contracting officer has to follow some procedures and decide which of these do I take, which of these do I simply reallocate. As a practical matter, these are usually very small dollar items, ink cartridges, pads of paper, and so forth. So it's unlikely that the government would actually bag them and take them away. It's more likely that the government would reallocate them to another contract that Raytheon would have. But in the case of the pouch foods manufacturer that went bankrupt, the government would have the right to go and take 80% of the items. It wouldn't have the right to take 100% of the items. And the value to the government, my brother is correct, that the value to the government in these items is their financial value as opposed to the things that the government is going to do in a particular contract. Direct cost items are ones that are allocated to a particular contract, and there's no dispute between the parties as to those.
In a sale for resale, because you say these fit within the definition of sale and ergo resale, right?
Yes.
In the usual situation, this is the question, I take it that the ultimate consumer, and therefore the ultimate seller, a tax gets paid, right?
In most situations, not all.
Okay, because there certainly would be no tax in this situation.
That's right. Let's suppose that that I were representing the kind of business that the Attorney General's office would recognize as a wholesaler.
Right.
Leave out that side of the case. If the wholesaler sold to the U.S. government, there would be no tax. If the wholesaler sold to a 501c3 charitable organization for profit purposes, there would be no tax. If it sold to somebody outside the U.S. of Massachusetts, there would be no tax. So usually there's a tax, and so usually what the resale exclusion serves to do is to prevent double taxation. But there are some instances where there would be no tax, and so what the resale exclusion serves to do is to direct our attention to the ultimate purchaser and assess, is there a tax there or not? And when it's the U.S. government as the ultimate purchaser, then there's not.
Usually, there's a transfer. I understand the word sale has both. I get that. But as a practical matter, in the usual sale for resale situation, there is actual transfer of the item, is there not?
In most instances, that's right.
These are items that you have anyway, that you have to have, that don't have anything to do with your government contract.
Well, we have to have this type of item, but if we didn't have any, U.S. government contracts are 80% of Raytheon's business, so if we didn't have them, we would only have 20% as many of these items.
But you couldn't even bid on these contracts unless you had a huge plant and all this equipment.
Well, we can't bid on the contracts unless we agree to abide by the terms of the contracts, which we have done for many decades throughout the history of Raytheon, essentially. The concept of federal title has been there longer than Raytheon has been in existence, so Raytheon has grown up as a business in which 80% of what it does has to be in compliance with these regulations. But you're correct that if we unfortunately did not have U.S. government business, we would still have to have some ink cartridges and papers and pens, but it would be 20% as much. So when we go to purchase them in the real world, the quantity that we're purchasing is 80% title will pass to the U.S. government and 20% it won't.
But how do you distinguish from the coffee cups in Jan Company or the travel brochures in the Franklin Press case?
Here's how I distinguish. The issue in those cases, I think, which the court worked to address is, was there a resale? In the Clark-Franklin case, this was the brochures that the printing company printed. The printing company's affiliate sold tours. The customers bought tours, which gave you, I suppose, airplane tickets and travel guides and so forth. The customer also received a brochure, which said this is a great tour. That had no value to the customer, the court held. It was a promotional item. It was given because the company wished the customer to have it. So the holding of that case is that there was no resale. In our case, under the definition of sale, there have been.
It's for such a different purpose. I mean, the resale is for such a different purpose. I mean, the federal government has zero interest in your toilet paper. Right?
The federal government has only a financial interest. The federal government
Well, your
doesn't.
golf umbrellas and keychains, I mean, what do they have to do with all this?
Same thing.
But aren't they like the travel brochures?
No, because the U.S. government, another major difference from the travel customers is that the U.S. government has extensive auditing and regulatory control over what Raytheon does. Raytheon can't give keychains to its employees unless it complies with federal regulations on the kind of programs that the government wishes it to have for employee morale programs. The record shows that the U.S. government has people on site all the time at Raytheon's location monitoring what it's doing to make sure that it's compliance with the government regulations. But you're right, the government doesn't want to have its hands on the keychains. The government wants to have the financial value of the keychains. So the testimony is, in shorthand, that the government pays for 80% of Raytheon's costs. And the government has title to 80% to everything that it pays for. Now, I'll grant you that the transfer of title here is different from the ordinary person's understanding of what do I buy when I go to Burger King. But it fits within the definition of sale and resale. The definition of sale is any transfer of title or possession for consideration. So that's much broader than the ordinary person's understanding. Also very different from the ordinary person's understanding is that the government has title to everything that it pays for.
Mr.
Not-
Buchanan-
Well, it has title. Go ahead.
No, go ahead. Go ahead.
It has title, but I continue to look at these federal regulations, and maybe I don't understand them. But doesn't title convert back if the stuff that's been purchased hasn't been incorporated into things that have been delivered to the government? Doesn't then title revert back to Raytheon?
There's a further provision that where the items are deemed consumed, then the title does not revert back. So these items are deemed consumed in the year in which they're purchased. So the dollar interest, if you like, is extinguished and replaced by new things.
Mr. Buchanan?
No, go ahead. Go ahead.
You started off by saying this was a first impression case, but other jurisdictions have looked at this same issue.
Yes.
How have they come out?
Well, in California, which was the first in around 1980, the California court held that there is a resale. The U.S. government takes title to its allocated portion of these items, and that's a resale. And so the items were purchased for resale, therefore exempt from sales tax. Missouri held the same in the McDonnell-Douglas case. Arizona held the same in Motorola. And Texas held the same in the case of Raytheon.
Are there any go the other way?
Not on, well, I need to tell you about a case which came down after briefing in this case, which was a trial court decision in Rhode Island against Raytheon. So there's a trial court decision against Raytheon on a statute.
I thought I read in it was perhaps Mr. Casey's brief, but in one of the briefs, that if we don't agree with you and we agree with the commissioner, the federal government will pay the sales tax and then, I guess, add it on to the price of the contract somehow. Do you agree with that statement? And doesn't that hurt you if it's true?
Well, it's important to understand that that is true. Sales taxes are, when they're properly owed, are an allowable cost, and the U.S. government reimburses them. The same regulations say that if you have a good faith basis for asserting that you're not subject to sales tax, you should assert that position.
Yeah.
So-
Is there no preemption issue in this case?
I don't think so. Many cases have examined the question, and I don't think so. The constitutional rule is that the state can't impose a tax on the United States, but the state can impose a tax where the incidence of the levy falls on the contractor. So Raytheon is subject to state taxes. The question is, does the statute as written by the state make for an exclusion? And to answer Your Honor's question, California, Missouri, Arizona, and Texas all rule on the same type of statutory language, that there's an exclusion. The legislature could change that. There is, for example, a case in Colorado from 1991 where the court examined a case where the exclusion was for wholesale sales. That's a different statute than we have. I would submit that the Attorney General argues this case as though our statute said an exclusion for resale in the regular course of business by the type of business that has as its primary purpose selling these items to the public. That's not what our statute says. Our statute says exclusion for resale in the regular course of business. So our argument is that we've established resales, and it's in the regular course of business, ergo qualifies for the exclusion. And the point of argument, I think the...
Could I finish your sentence?
I think the commissioner doesn't dispute that the title transfers, and doesn't dispute that that meets the definition of resale, but argues that under this court's case law, that's not sufficient to meet the words of the statute, resale in the regular course of business.
That's really my question. I'm wondering whether Texas, California, Missouri, and Arizona, I think you said, whatever, the other states, do they have is their jurisprudence similar to ours, that is, sales that might be considered for resale that are incidental to the business of the ongoing, of the taxpayer, may not qualify for this exemption?
Well, every state, of course, has zigs and zags in its jurisprudence, and I'm not aware of ones that use the same language in the course of exposition. But I think it's important to go back to this court's holdings to ask what was the court analyzing. The first of these was the Prince case about going to an amusement park and buying tickets to play a game. The taxpayer argued that where the customer won a prize, the customer was purchasing the prize. And the holding of the court was that's not correct. The customer was buying a ticket. And the holding of the case was that when the customer was given a prize, that is not a sale. In our case, by contrast, I think it's not disputed that we fit within the statutory definition of sale and resale. The next case was Clark Franklin, which we've discussed. And the next was Janko about napkins and wrappers and so forth at Burger King. Well, if I go to Burger King, I buy a hamburger. I might be given one napkin or five or one package of ketchup or none, but that's not what I'm considering that I'm buying. And the holding of the case in Janko was there exists no resale of the same product. Here, by contrast, the U.S. government contracts to take title and gets it and pays for it.
Thank you, Mr. Buchanan.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Tim Casey. I'm an Assistant Attorney General, and I represent the Commissioner of Revenue. Justice Cordy, I want to jump, if I could, right to your question about what happens to these goods after they're used in the performance of the contract, because I think it's an important factual point. And you're right to identify a provision in the Federal Acquisition Regulations that talks about what happens to title after performance of the contracts. I'm looking at a provision that is appended to Raytheon's brief at pages 32 and 33 of the addendum, and it talks about...
Those are the regulations I was focusing on.
Yes.
I wasn't sure I understood them.
Yeah, and Your Honors, they make clear that for goods that aren't part of the end product that is delivered to the federal government or that aren't consumed in the completion of the contract, title reverts back to Raytheon. Now,
So that would be the cell phone or anything else?
that's right, or the golf umbrella or the lapel pin. Now, I raise that point not to suggest that legally it defeats the original transfer of title, but as a factual point to suggest that the federal government really isn't interested in these items other than to secure payment to use as collateral to make sure that Raytheon does perform what are its principal obligations under the contract.
Can I ask you this? Let's assume for a moment it's not the federal government that has this contract with Raytheon. It's a private manufacturer, Boeing or something like that. And but the contracts are structured the same. In other words, Boeing will pay a percentage of the indirect costs on the same formula that the government would. 20% of the business that Raytheon has is with Boeing, so they'll pay 20% of the indirect costs. And it goes through the same process. Presumably the items are itemized, and there's a cost associated to it and a bill paid. Would you be taking the same position?
We would, Your Honor.
Would you say Boeing owes a tax because they purchased, both Boeing and Raytheon owe the tax?
That's right, and that is effectively what happened in the Janko case, Your Honor.
Yeah, but Boeing is subject to the tax, isn't it? Whereas the government here is not.
Well, that's right, but just to be clear, the transactions that are at issue here are not the sales from Raytheon to the government. They are the sales from the vendors to Raytheon. So those are the transactions that either are resales or are not.
Correct, but then you would say, well, those are taxable to Raytheon. They should have paid sales tax on that. And Boeing, in turn, is purchasing those same items through its indirect cost accounting and reimbursement methods. So would they also be subject to the sales tax?
I think they would, Your Honor. And in Janko, this court addressed that very question. It said we're sensitive to the idea of pyramiding of tax, of taxing a sale or a good along multiple stages of a transaction. But the answer to that is there are multiple taxable events along this transaction line. And if the vendor or the purchaser wishes, just like with any other cost of producing the good, they can pass along that cost to the end user or not.
But that suggests that the purchaser is really purchasing the item for its use. I mean, Boeing is really purchasing the item. Right? Here you're sort of saying the government really isn't purchasing the item. They're sort of taking title as security.
Well, Your Honor, I don't dispute that the transactions involve a sale as that word is defined in Chapter 64H, Section 1. It is a transfer of title for consideration. But that doesn't mean that a resale in the regular course of business has taken place.
You would say in the example that Justice Cordy said, if we substitute Boeing for the U.S. government, that Boeing would pay the tax on the lapel pins?
If Boeing were the end user? No, the sales tax is imposed on the vendor.
Yeah, the question is whether the tax would be imposed on Raytheon and Boeing.
Yeah.
It would be.
And you said yes, I thought.
Yes, Your Honor, I believe that's so. It would be taxed on the original vendor and then on the intermediate user. So in your example, if Raytheon sells
You mean
to,
if Boeing takes this security interest, it would, the Raytheon would pay, I mean, Raytheon or Boeing would be charged with this, with the sales tax for that?
the vendor would be charged with the
Yes,
sales tax.
The original vendor.
That's right, Your Honor. That, as I understand it, that is effectively what happened in Janco. The Janco was,
Vendor would be,
right.
but then when, but because Boeing, I'm sorry if I'm, but because Boeing has this security title, you're saying Boeing would also pay a tax on that?
No, not the fact of the security interest or the title or whatever you choose to call it is not the basis for the separate taxation. It's because maybe it is in the sense that another sale has taken place that is a taxable event.
So if you recognize that a title was conveyed to Boeing, you have to recognize that title was conveyed to the United States.
I don't dispute that title was conveyed to the United States. I only raised the conceptual problem.
So if title was conveyed to the United States, there's no sales tax owing on those items.
That's not the phase of the transaction that we're looking at in this case, Your Honor. It's the phase of the sale by the vendors to Raytheon. And the question is whether those purchases were for the purpose of reselling them to the government.
Yeah, but it seems to me you can't have it both ways. If you say it wasn't for the purpose of reselling to the government, but nonetheless, if you substitute a taxpayer for the government, Boeing, there would be a tax on that sale, whether it's for the purpose or not. You're saying there's a taxable event.
I'm sorry if I've misunderstood the question, Your Honor. All I mean to say is that a part of the transaction present in this case, which is a sale to the United States government, which renders it exempt from the sales tax under Section 6D of Chapter 64H, isn't in place. So we would be separately analyzing that sale from Raytheon to Boeing to see whether it was for resale in the regular course of business. But I don't, and this is a vital point, Your Honors, I don't mean to suggest that the Commissioner acknowledges that under the terms of the contracts and the federal acquisition regulations, title in the goods transfers to the federal government, and therefore technically meets the definition of sale in the statute. That does not mean that a resale in the regular course of business has taken place. This Court's decisions in Janco and Clark Franklin Press make clear that that phrase, in the regular course of business, is the vital central part of the inquiry.
Is that what distinguishes this case from, let's just take Strayhorn?
Your Honor, not necessarily Strayhorn, because Strayhorn does address this issue, but as we say in the brief, they give it a fairly short shrift. In the other four cases from the other states, there is absolutely no consideration of the phrase in the regular course of business.
Although the statutes in each of those states include that.
That's right, Your Honor.
And
that's right.
mentioned in the opinion.
It is, but in all of those cases, the fact that title transfers to the government for consideration ends the inquiry. That is the basis for the decision in those four cases. Now, in the Texas case, the Strayhorn case, the Court did consider whether this happened in the regular course of business, and in less than a paragraph, it said the Texas version of the Commissioner of Revenue says that that Raytheon is in the business of making machines of war. We disagree. Move on. That was effectively the extent of the inquiry. And I can only surmise, Your Honors, that the phrase regular course of business there means something more like, is it something the business does on a regular basis? That it doesn't have the vital importance it does in this Court's decisions in Janco and Clark Franklin Press, to wit, is it part of the inherent nature of the taxpayer's business to do what it is that they're doing in this case? And is it part of the basic purpose of the contract with the end user? Raytheon suggests that those are glosses that either the Board or the Commissioner puts on the otherwise plain meaning of the statute. That's simply not accurate, Your Honors. Those are interpretations that this Court has placed on.
We've used those words, but in the cases that you point out, all of which are important, it seems to me that one of the common sort of notions is that there's not really a sale here. There's not really a resale, I should say. The brochures are just provided as part of the tour. the napkins are provided as sort of to wipe up the ketchup if it drips off your burger, that they're not really being resold. The prize at the amusement park's not really being resold, so there really is not a resale.
Your Honor, in Clark Franklin Press, the court considered essentially the exact same argument that's being raised by Raytheon here, which is possession transfers and consideration is paid. Therefore, the definition of sale is met and a resale has taken place. This court said that analysis was, quote, rather simplistic and rejected it.
But if the legislature had wanted to say that in the regular course of business means that your principal business activity is selling coffee cups and toilet paper and things like that, it would have said that. It didn't say that. It said in the regular course of business. And this type of resale actually does occur in the defense business, doesn't it?
It depends on how you define regular course of business, Your Honor. I would suggest that,
how does the
comparing this case
legislature
to
define it?
Janko, for example, that it is a vital part of Janko's business to convey the fast food and drink in packaging and cups. You need those things in order to be able to sell what you sell, and yet the court still held that that wasn't part of the inherent nature.
Well, you need a
of Janko's
coffee cup
business.
to make a missile.
That seems even more attenuated, Your Honor.
What distinguishes those cases from this is that here there is separate consideration for the indirect. It's not as if McDonald's says the hamburger is $1.50 and the paper is 5 cents extra, and you can have it with or without the paper, and you're paying 5 cents for the paper. Here, the government's saying we're going to pay 0.8 of the cost of the indirect expenses, and then those become 0.8 Rs.
Your Honor, if that becomes the basis for distinguishing this case and reaching a different outcome, then I would respectfully suggest that the court is going to be providing a blueprint to taxpayers for how to evade the sales tax by saying as long as you separately itemize the consideration for these overhead items, it is a non-taxable sale for resale. An important part of the decisions in Janko and Clark Franklin Press was the court's suggestion that we're going to look at these things with respect to matters of substance, not with respect to matters of form, and we're not going to encourage artful drafting and opportunism by lawyers by elevating aspects of the form of the transaction.
Let's stick with that. Let's assume McDonald's says it's $1.50 for the drink and 10 cents for the cup. You would tax both as a sales tax, would you not?
Yes, Your Honor.
So you get your $1.50 and your 0.625, and now you're 0.0625, and you're 0.0625 for the 10 cents for the cup, which you wouldn't otherwise get if it's all part of the $1.50s. I mean, you're getting your sales tax on the final sale.
That's the second sale. We're
Right.
talking about the first sale.
Right, but why would you then get the wholesale purchase of the cups as well and charge a sales tax for that? I mean, what you're basically saying is you want to charge a sales tax on the wholesale purchase of the cups and then charge again on the retail sale of the cups.
As long as there is a separate sale that is not for resale in the regular course of business, Your Honor. All I mean to suggest is that whether or not consideration for the particular items in the contract, or series of contracts in this case, are separately itemized should not be the basis upon which the court's decision should turn, because that would elevate an aspect of the form of the transaction that would effectively be a way forward for taxpayers to avoid sales tax. As long as we, as opposed to billing generally or to the end user for all of our overhead items, let's say as a percentage of the total business that they do with us, let's itemize these out. We'll be exempt from the sales tax. That would defeat what this court has said in so many other instances in tax cases, which is that we're going to look to the substance of the transaction, not to the form. And in the case of the sale for resale exception, we're going to look at what does this company do for a living. Are they in the business of passing along lapel pins and golf umbrellas and toilet paper to the federal government, or are they in the business, as the Appellate Tax Board found, of making defense systems, missiles, aircraft, radar systems? This case, Your Honors, is on all fours with Janko and Clark Franklin Press.
Have these tax problems that you portend will occur, have they occurred in those other 5 states?
I'm sorry, which tax problems?
That this will be a blueprint for people to avoid having to pay
Well,
the
Your
tax?
Honor, in those cases, there was not, that was not the basis upon which the court's decision turned, this idea of separately itemized consideration. They said because title vests in the government as a requirement of these federal defense contracts, we find that a resale has taken place and that therefore there's an exemption. But again, Your Honor, those cases treat as effectively surplusage the language in the statute talking about in the regular course of business, which in this in the Commonwealth and the decisions of this court is the vital center of the inquiry. Thank you, Your
Thank you,
Honors.
counsel.